Get on the train before it leaves the station. The truth train is coming, gonna run them down, run them down.
Hello there, everybody. How you doing? Erekose here. We're here to talk about Stephen and Brendan tonight. We're going to be talking with Mr. Capaldi, the Hodd over here. We're just be kind of going over some of the things about the appeal, some of our thoughts about it. You know, have a little bit of a back and forth about some of the things that we think might or might not happen. And then we're going to talk a little bit about Brendan's clemency, a little bit about Evers, and get into that a little bit, and potentially bring up Evers' background, the fact that it's in education, and maybe get into some of those things and talk a little bit about all those things. But so we're going to start out tonight talking first about a little bit about Stephen's appeal. So how you doing, Mark? How you doing, Paul?
I'm very well, thank you very much.
Happy days.
Happy days. Dappy Hayes. Dappy Hayes.
Happy days.
There you go.
Hey, that was filmed in Wisconsin, wasn't it? Wasn't that the
It
backdrop?
was.
Milwaukee.
All right.
Right. Or at least that's where it was set, right? Milwaukee.
Yeah.
Anyway, so Milwaukee's actually south, or what is
Yes.
that like about? Is it central in terms of north to south, or is it actually southern in terms of?
In Wisconsin, you mean?
Yeah, in Wisconsin.
Yeah, it's sort of quite close to the southern border
Is it?
of
Okay.
Wisconsin. It's only about half an hour down to Illinois.
Yeah. I don't know how the heck you used to fly in there. Do you still fly in there?
Me to Illinois,
Yeah, you.
to
When you
Milwaukee,
go to
or to
Sorry.
I fly into Green Bay.
Yeah, you now you do, right? But I remember you used to fly into Milwaukee the first time we went there. You were flying into
The very
Milwaukee.
first time I flew into Milwaukee, I realized quickly that wasn't the best option.
Did you?
So-
Yeah. And then you met up with me in Manitowoc, where I said, "Oh, dude, I flew into this awesome little airport right up here in Green Bay." Austin Straubel.
Yeah.
That is a great little airport.
That's the one. Yeah, it's good. It's
Yeah.
very easy to get move in and out of.
Get in and out of it quickly. It's it's very convenient. I imagine it could get overrun easily, possibly if it is a small airport. So,
Yep.
but it can
But
only handle so much traffic. But it is nice, man. It's just like walk up, boom, boom, on a plane, out. Real easy. So anyway, we lost the mad havering Scotsman here. Okay.
Yeah, he probably had to pay a visit knowing him.
Yeah.
Yeah.
He's going to refill his pint. Anyway. So, all right. So we're going to talk a little bit about the appeal tonight. So,
Okay.
obviously, we're all eagerly, awaiting the state's response to Kathleen
Yes.
Zellner's motion at this point. We know they were given another 90 days. It puts it due somewhere in early February of 2020.
11 February to be exact.
There you go. So, so we're all kind of waiting for that. But in the meantime, we can talk about the motion that was filed, and all the issues in it. So, various issues in it.
By the
Like
way,
I
this
say-
is it.
Yeah.
I did a nice printed copy of it, so
Did you?
which I carry with me. So it's quite the document. To be honest, it's a work of art. So it's very it's fascinating to read,
that the
let alone the
original-
factual aspects,
Is
the
that
construction
the
of
original
it.
1,000-page or?
This is the one. Let me see. It goes up to 133 pages.
Okay,
So-
that's the recent motion.
But
okay.
but doesn't have all the exhibits and all that stuff would be extra to that. So it's just the actual written part. So
okay.
yeah.
So, all right. Well, so, like I say, the appeal is appealing. Number one, the denial of the original motion for post-conviction relief that was
Yes.
filed. Like I said, that's the big 1,000-page thing that she filed originally. Then there's the supplemental motions where she filed about the computer information, the filing about the, Bobby and Scot, the information about the sink, all these things that she filed that were just, not even looked at really by Judge Flowers, as some call her. She talks about, and I think for me, And I know why she led with it, because for me, the one that has the most powerful, like, kind of, oomph is the first one, because she's talking about how her and the prosecution expected an evidentiary hearing because, by the letter of the law, if the evidence is stronger than it was previously, and there was a previous hearing granted, an evidentiary hearing granted, if the evidence is stronger and it's not merely cumulative, then an evidentiary hearing should be granted. It's basically like a foregone conclusion. And you can tell that the state felt it was a foregone conclusion because they were dealing with Kathleen Zellner. They were setting up for her to come and test the RAV4 at Calumet County Sheriff's Department. They were setting these things up to happen. And it's funny because they handed
over evidence for her to test as well. So
yeah, they did give her some evidence to test, obviously, originally, but as she was dealing with them to get more evidence and test more things, for instance, the skull fragments. Chris Palahniuk over at Microtrace really, really, really wants to examine the skull fragments. He has some suspicions after looking at the radial spectrography of the skull fragments, and so he desperately wants to get those underneath his Microtrace microscopes because there's some hunch I think he has that he wants to prove. So that was part of it too, that those were going to potentially be sent over to Microtrace. Those were things that all that were in the works, because the prosecution was basically automatically assuming that there was going to be an evidentiary hearing granted, and they were making these deals with Kathleen Zellner in the spirit of the order issued by Judge Willis, that evidence be saved for testing and everything. So it's agreed by both sides, Zellner and the state here, that they were both doing that in the spirit of the order issued by Judge Willis. And so that's the interesting thing. And then when Kathleen Zellner asks Fallon, should I let her know? Should I let Judge Flowers know or whatever? Fallon basically tells her, well, just give it a couple days, and when we figure out the logistics of getting the RAV4 to Calumet for you to come and look at it and test it, then we'll file something or whatever, something to that effect. And before that actually happened, before the logistics got figured out, within that 2-day period, that's when Judge Flowers' decision came through and shut it all down. And as soon as she denied everything, the state was in full retreat. Fallon and everybody were in full retreat. And to me, that is the biggest proof and the biggest indicator that Judge Flowers is not really being honest in this. That even all the actors of the state, all the people involved in the state that tried this case, Fallon gone, and now this new guy, Mark Williams, they all thought that it was headed for an evidentiary hearing, and it's interesting that she ended up just denying it completely. So, your guys' thoughts?
Well, I'm a little concerned because the Hodd was saying that he's bought some flowers and he's going down to Sheboygan on a date, and he's going to take Angela Sukovich out.
Okay.
Yeah. So I'm just a bit concerned about this.
Here's the Hodd.
I appreciate your you're a bit annoyed at her, but maybe taking her out is just taking a bit too far. No, she's just like all those others. When you look at the press reports, it's a case of everything is slanted towards the prosecution in this case. The state. It was, for me, it was an eye opener, or sort of when I read about the fact that everything is filtered there. All the press reports, everything journalists do, it's all about presenting this illusion of justice. Making a murderer showed the world exactly what was going on. Mm-hmm. Wisconsin isn't ready for that. Angela Sukovich's voters aren't ready for her to be exposed as being corrupt as she is, and a lot of the other people over there in certainly in Manitowoc, Calumet, etc. What what you pointed out is immediately, of course it was. Tom Fallon is playing a whole load of shenanigans with Zellner, with this whole idea that we'll have an evidentiary hearing. Well, I better let Sukovich know. And I remember at the time, everybody was some YouTubers were getting really nasty at Zellner, saying she doesn't know what she's doing.
Yeah.
I remember
because it got denied
she
before.
doesn't know what she's doing.
Right. I agree. It was done in an underhanded way. Yeah.
So that's my rant over.
Mark?
Okay. Well, look, I take a fairly sort of pragmatic approach to these things. I see the process of review as just as much part of the overall process of justice as any other item. And the courts provide, when it comes to an application for post-conviction relief in the form of an evidentiary hearing, the standard is that provided that the evidence is not just recklessly thrown to a court, that the presumption of its validity is intended to be accepted, and therefore you call the evidentiary hearing to examine whether in fact there is veracity and support for that presumption. It's not for the court to act in judgment unless it's just reckless information. It's for the court to say, yes, on the assumption that there is validity in this, we think it's deserving of an evidentiary hearing
to flex. District attorney and try to argue the case for the state.
Correct.
Right.
So, and Angela Sukovich, her approach has been both lazy, lacking any sort of thorough analysis of the facts, and showing not only for herself, but showing to the process a total disrespect for what should be going on here. If in time, in a court, they find the evidentiary hearing matters, if they find against Stephen Avery on those matters, well and good, that's part of the process. But to prevent the examination of this substantial amount of newly discovered evidence, including 6 Brady violations, is just a reckless disregard for what the justice system is supposed to be about. And it's shameful that she should take that approach. And I'm just pleased that it's in the hands of a higher court that will hopefully have a more intellectual and professional approach to this information.
Right. Yeah.
I personally can't see any reason at all why they shouldn't grant an evidentiary hearing on the basis of this. And we know from what you had said just a moment ago that the state, some time ago, about a year ago, were preparing for that anyway in the discussions directly between Kathleen Zellner and Tom Fallon and company. So they know that
believe that was going to happen, right?
And they would only do that if they felt it was warranted, right? They wouldn't do it just to be nice. So I'm just hoping that we've had this sort of 1 year delay or more from the shenanigans of the lower court, and we need to move past that quickly and get on with it. Get on with the evidentiary hearing.
Yeah,
which is a court mandated process where people give evidence under oath, and it forms part of the record, which is what you want to do. So,
which is what a judge needs to be able to make a decision, is
correct.
To be informed. So
correct. Yes.
Yeah, I agree. Judge Sukovich is definitely looking pretty shady at this point. The way this all went down, but like I said, that argument I think has a lot of power, and we know that the Court of Appeals was not amused with the state's appellate lawyers arguing how Stephen was barred from bringing the issue about the bones, how he was procedurally barred from it, how even if, basically that was like their argument. And you could tell the Court of Appeals in their decision when they decided to remand it back, they were not amused. And they were certainly not amused by the state's appellate lawyers arguing that Stephen should drop his current appeal and all of the issues there in it, in his appeal, so that he can pursue that one issue. Instead, because of the issue of if he doesn't raise it now, then he could be procedurally barred from it later or whatever. So that's why she was bringing it up now, so that, ultimately it could be revisited without being procedurally barred. But that's what all this stuff is about. So you could tell the Court of Appeals was not amused by the state's argument in that. and that it was a big part of them remanding it.
Yeah,
Well,
and that's a valid
Okay.
concern. It is about the seeking of the truth. That's what this is supposed to be about.
Right.
And an evidentiary hearing, given the weight of newly discovered evidence, significant newly discovered evidence, an evidentiary hearing is the mechanism through which that can be properly and independently and legally examined.
Right.
And that's what we need to have. We've needed to have it for a long time, but fortunately, it's gone past the lower court level, and hopefully, in February, it'll be the trigger when we hear the state's response. It'll be the trigger to get a proper court examining this newly discovered evidence to determine the appropriateness of an evidentiary hearing.
Well, remember, these are the lawyers before that kind of obviously kind of set the Court of Appeals kind of a little bit on edge, So it'll be interesting to see what they come up with this time.
I know. I just seriously, I regularly contemplate what it is that they would say in reply, but I guess we'll just have to wait for another couple of months.
Right. Paul?
I've got two questions, one for you and one for Mark.
Okay, fine.
For you, it's been suggested to me, and I would like your opinion on this thought, that Stephen and Brendan were kidnapped by the state and are being held as political prisoners.
Kidnapped and okay, I'm gonna say no.
Okay.
Because they did it through legal means. You can't call it kidnapping. I guess I don't know.
I know.
That's the technicality I'm gonna stand on.
Okay. I appreciate it. It's kind of provocative terminology, but can you see the analogy?
Yeah, sort of, maybe.
Yeah. Because that's basically what you're saying, isn't it? That you've got this judge who's determined to keep Steve behind bars.
That seems to be, invested in helping the state keep the genie in the bottle. Yeah.
Yeah.
Yeah, that's true. And but you could also say that at the trial level as well. So and absolutely. Various law enforcement personnel who contributed to the trial. So
okay, and for Mark, I've got a question for you.
Yes.
Because you've obviously been visiting Steve.
Mm-hmm.
What were his opinions on the state getting a 90-day extension, or did he express an opinion?
Well, obviously, he's frustrated by the delays because he's the one suffering the most. But Stephen's pretty pragmatic. He knows that they're entitled to extensions. So as much as he's frustrated about it, he says, okay, well, that's it. I have to just wait a bit longer. And, what would be extremely frustrating if they come back on the 11th February with either nothing or next to nothing to comment on, which would just show the laziness of that approach. But he's not up in arms about it.
Yeah.
He's not up in arms about it. He's just a patient. Stephen's a patient man. And let's face it, he's had to be. And so he's guided by his lawyer in Kathleen Zellner, and he also can't see how on earth they'll come up with responses to the motion, the range of motions that would give him concern that he wouldn't get an evidentiary hearing.
Mm-hmm. Okay, that's that's kind of I suppose what I was thinking. That there's no.
I know he gets impatient though. So
yeah, but what can he do about it? There's not a lot that he can do about it at the moment. He has to trust in Kathleen Zellner, and I think we all do, don't we? It's she's doing her bit. Obviously, you've got Steve and Laura trying to do their bit for Brendan, who for me is even more of a political prisoner. Because I mean, What why is that boy still in prison? You know,
Oh, I know, right?
It's just ridiculous. It's
The fact that the state, Brad Schimmel, fought it to that point and the fact that it suddenly turned around like that after 2 wins, and it suddenly turns around like that, and then the Supreme Court just thinks, oh well, there's nothing to see here. It's like, you're kidding,
Mm-hmm.
right?
no,
This is a habeas case that managed to win twice.
yeah.
An on-bank review is suddenly instituted, and it gets overturned the opposite direction. And it's like, and that's not it. That's not. You don't think that there's some issues at the heart of that? I mean, I can't believe SCOTUS passed it over. It was SCOTUS's big chance for me to give mentally limited juveniles similar to Brendan a path to, get out of the fishbowl of whatever state or whatever, little pool that they're stuck in. That habeas relief could have given some of the juveniles in our system a way to get to the federal courts, where the federal courts could start trying to keep these state courts honest when it comes to juvenile interrogations and that sort of stuff. That's what the Supreme Court could have done here by making a decision on Brendan's habeas case. And they really, to my mind, dropped the ball.
Well,
because seriously, if you're going to deny, I mean, I get it. You wanted to deny terrorists, you wanted to deny people on death row, and that's why AEDPA came into existence. It ended up robbing all of us. But you know what? The Supreme Court's interpretation of that legislation is what led to robbing all of us. So the Supreme Court's interpretation could turn it around. And if the Supreme Court decided that juveniles should not be subject to AEDPA, I think that would be a good start.
Well, hold on a sec. You've got a situation over there just this week in Baltimore. Is it Maryville or what is it? Where there was those 3 guys have just been released recently. They were convicted as teenagers. They spent 36 years behind bars. And if you actually read the report about it, there was 3 guys. Was it Watson? Somebody Watson, something Chestnut, Watson, and somebody else. And do you know what actually turned it was the Conviction Integrity Unit actually looked at the case.
Right, good.
And that's what overturned it.
Good, that's good. That's why we need more conviction integrity units in operation. Because like I said, nothing gets a wrongful conviction overturned quicker than when the state and the DA's office are on board themselves.
Do it themselves,
It happens in rapid fashion.
Yeah.
So that's I definitely applaud them. Sorry?
And the mere existence of them is a forward speed bump to actions preempting bad behavior. If you think, we're all fearful and mindful of consequences of incorrect actions or bad behavior, and if you have something like a conviction integrity unit and other things, then that in itself is going to curb the thought of bad behavior.
Yeah, I believe that's a fair statement. So that brings us, well, I guess we could talk a little bit about the fact that, I believe, and we can see what Mark believes here, but I believe that we're most likely going to see an evidentiary hearing come from this appeal based on, some number of the issues being raised. Somewhere, I think, maybe between 2 and 5, let's say, of the issues that they will decide they want more fact-finding on. And then I think it's going to be an evidentiary hearing. I don't believe that the Court of Appeals at this point in time, even if they really, really are, believing one of the, or are really behind one of the claims being made, and like they're seriously considering it, I'm thinking that they're going to be loath to just overturn the conviction. That they're going to want more fact-finding before they actually do something like that. That's my personal opinion, so I don't think that an overturned conviction right away in the immediate future is really going to be an option. But maybe I could be wrong. What are your thoughts, Mark?
I guess, well, firstly, my focus is on an evidentiary hearing, because the fact-finding you're referring to is the information that would come out in an evidentiary hearing to give the justices comfort about a decision. Right. So if they have an evidentiary hearing, they conclude from that either there's no grounds for any further action, or that there's grounds for a new trial, or there's grounds for Stephen to be released straight away. But we have to have the evidentiary hearing at this stage. It's not a matter on the record yet. We've had no attestation of the validity of what Kathleen's saying and those that of the state and how they happen to respond. Right. We need that evidence on the record, and I'm not sure. Someone might know better than me. Obviously, someone would know better than me. I don't think the appeals court can cherry pick the items that they're happy to have heard in an evidentiary hearing. The evidentiary hearing is the examination.
What I meant was,
I don't think it's Brady. Well, that's part of the evidentiary hearing, right? If you've got listed 5, 6 Brady violations, it's a matter for an evidentiary hearing to flesh out the facts behind that. Mm-hmm. They're not reckless. They're not reckless claims. They're based in hard evidence. Right. So the evidentiary hearing should be there to flesh that out, and then they might say we don't find any grounds for Brady violation 1, 4, and 6, but we do for 2, 3, and 5 or whatever. But it's not for them to cherry pick the items before a hearing. I wouldn't have thought so. I don't know how they have the ability to do that without the evidentiary hearing itself. Did.
She denied it because she said the Brady violations didn't meet the 4-prong test that a Brady violation needs to meet. That was Judge Sukowicz's argument. So it's always up to the judge. The judge always ends up, making the decision, right? So you're always kind of somewhat at the mercy of the temperament of the judge.
But there we have Angela Sukowicz playing, judging the application. It's not her role to do that until you actually have the hearing, because before that, all it is words on paper. You have to bring people forward to give evidence under oath about the merits of the issues. Whereas Judge Angela Sukowicz was trying to take 2 steps and wrap it all up, at that preliminary Part A stage. The role of the appeals court should simply be to say there is sufficient veracity and integrity in what's been claimed here. We should have a hearing. Whether they accept it all or accept any of it at all is a matter for the hearing and the consequences that flow from that. But this is not a reckless claim.
Right, I agree.
And so, that's the point. We just want the hearing. Yeah. They can choose not to accept any of the information after the hearing. We already know from utterances from Kathleen Zellner that it's expected that the hearing would probably last at least a month, maybe more. This is a weighty set of documents. So we're going to learn a lot from that. And the justices who have to rule on the evidentiary hearing will learn a lot from that. And if I was one of them, I'd want to know the detail that sits behind all of this. Yeah. Whether that leads to, as I say, a new trial or exoneration or immediate release, I should say, that's not even on my mind at the moment. I just want to get to the situation where these matters are heard in a court of law, and the evidence can be fleshed out.
Right, Paul.
Well, I would just ask. I totally agree with everything that you're all saying. So, my question, I suppose, would be, well, when does the actions of Angela Sukowicz herself become a violation?
Oh, I mean, if you
look at Lincoln.
I mean, seriously.
Should it?
I mean, she shouldn't be in that. She shouldn't be in that role. I mean, with due respect to her as a person, who I don't know at all, obviously, but in terms of her competency as a judicial official, given what we've seen so far, she shouldn't be in that role. As simple as that. So, yeah, and it's like Elaine Kaczynski. Probably not as bad as that, but it's like that.
Well, but
they're not capable of performing the role.
I mean, look at what he was doing and how hard it was for him to get out. And even after being convicted by a jury and supposed to be serving 6 months, he gets let off of that too. And get back to work. Here's your public defender cases. You know, so I mean, yeah, it's disturbing what's going on there. It's way disturbing.
Yeah.
But I mean, I'm sure there have been cases where judges have been hauled up for their actions in cases, haven't there?
Yes.
Yeah. So
Yeah.
there is the possibility that at some point in the future, because eventually the ship will turn.
Right.
And
Yes.
and things will start pointing in a completely different direction. And then what you're going to get that sort of whiplash effect whereby all of a sudden everybody is going to be looking at what on earth happened here. And everything
Yeah.
that she's done so far will come back and bite her. Surely.
She's just been a pawn in the game, and she's played her incompetency card, which was the only one she knew how to play.
Mm-hmm.
And the effect of that is just to delay what's inevitable and where we kind of are at now. Whether there's any review within to determine whether her performance was appropriate or incompetent or whatever, who knows? But you'd like to think there'd be some sort of process of review of she gives these brief reports to major documents and everyone just accepts, oh, that's Angela Sukovic. I mean, seriously? Is that how you generate quality control inside an organization?
Right.
Yeah.
Yeah. So. Yeah, Judge Sukovic isn't ideal, but like I said, by what Travis said, that the Court of Appeals, if they order an evidentiary hearing, which I think is likely, they could there's a 50% chance they'll send it to Judge Sukovic, which I immediately went, what? Are you kidding me? He goes, don't get too disparaging about it. He goes, usually when it comes to the point of the Court of Appeals sending it back again, the judge tends to snap into line and do their job correctly. And because they realize that the Court of Appeals is serious about it. He goes, that's what happens most of the time in that 50% of the cases. He goes, other 50% is they send it to a completely different judge and they have that judge conduct the evidentiary hearings. So that's what we're looking at potentially happening here. So that's about that for Stephen.
Okay.
To move on, I'm sorry. Anything else?
No, you're right, mate.
Brendan, so.
Okay.
Yeah? Okay. Anyways, so we're going to move on to talking a little bit about Brendan. Obviously, we were talking a little bit about him already. The fact that he's still inside is just, an embarrassment to Wisconsin. More and more legal minds, people that are well known in the legal community, more and more of them are coming out and talking about what a mess it is with Brendan Dassey, what was done to him, the way that the read technique was used, criticizing virtually any aspect of the interrogations of Brendan. And obviously we now have the fact that his lawyers have petitioned Governor Evers directly for a executive pardon based on actual innocence. So we're waiting to see what's going to happen with that. But that's one step in this process. And if that gets him out, then that will be at least enough for now, where he can at least be out of prison and able to live in the real world. And like I said, he's going to have plenty of opportunity in the real world to do things that he loves, and he'll probably be able to make a pretty nice living to support himself off of it as well. And so I'm excited for Brendan when he does get out. So that's what we're hoping for, and that's what we want. And we hope Governor Evers sees the merits in Brendan's case. Mark?
Yes. Look, you empower a governor with this discretionary authority to look at something on the balance, almost on a humanitarian point of view, let alone the factual side. But by any measure, there is serious doubt about Brendan's conviction, both in terms of the way it was conducted, the lack of evidence for anything from any other source other than this so-called confession. Judges at the federal court have, in fact, I think if we add them up, there's been 4 judges of the federal court have said that it's an involuntary confession.
Yeah.
And Brendan has been a model inmate. There's nothing to be served in the interests of the state by keeping him in prison. And in fact, you only then have to listen to all the very powerful and knowledgeable people who, beyond us well-wishers and good-intended people like us, but the serious, experts in the field that have supported Brendan's petition for executive clemency.
Right.
They're not doing that just because they want to. They're doing it because they believe it's the right thing to do.
Right.
Now, whether Brendan ultimately gets a pardon for the crime, I think that is, to me, a secondary thing. It's an important thing, but it's secondary.
Yeah.
And I don't think that has to be the basis upon which he gets released. I think he's deserving of release. There's a serious doubt about his conviction, and there is significant, meaningful support to support that, and that's the role of governor. If you're going to have this power, you need to exercise it. And I don't know what he'll do, but I can't think of a good reason why he shouldn't exercise the power and allow Brendan to go home.
Right. Yeah. Paul?
Well, yeah. My concern would be if obviously we want to see Brendan out, but it's on what terms, and what does Brendan have to agree to, or concede to? What this whole idea on that he's going to be released on actual innocence. I like the idea. I'm just a bit concerned as well. How is that going to work? So that Governor Evers is going to bypass everything that's to do with the way the processes work. I'm reminded of the murder in the park scenario. I don't for one moment think that Wisconsin is going to suffer the same as Illinois did.
Right.
But I'm just a little bit concerned about what are going to be the terms of this, being pardoned on actual innocence, because if you're going to pardon him on actual innocence, so what you're saying, he is totally innocent of it, yeah?
Well, they're petitioning it on actual innocence. What it gets granted as is a completely different thing.
To me, it's like I want, and don't get me wrong, I want to see Brendan out. Yeah, I think it's appalling what they've done to him. Mm-hmm. My concern,
but you don't want him to be cut off from ultimately proving his innocence.
And I don't want there to be a detrimental effect on Steve in the process, in what's on whatever terms. Does he have to sign some sort of agreement that? Oh,
right, I know what you mean.
That's not going to happen. That's not going to happen.
Well, that would be my only concern. Other than that, I agree with everything you say. It's that's a concern, if you like. It's and I suppose it would be for Steve as well.
That's not going to happen. That's not the role of the governor's power. Mm-hmm. The governor's power is to exercise his best humanitarian judgment based on facts and circumstances. It's not about saying, well, for example, if you said you're guilty, we'll let you go. That's not the role of the governor in this situation. Mm-hmm. So I don't think we'll see that happen, and that would never be accepted anyway.
No, like I said, I can't see. This sort of bypassing of judge and jury retrial, to suddenly have, Brendan sort of walking free. But the whole system I find confusing at times. You know, there's been a lot of talk about this Alford plea. I think amongst supporters, I think that is one of the number one concerns, that Brendan is somehow gonna accept the Alford plea or some Wisconsin equivalent of it, because I believe the Alford plea is something in Carolina.
Why would that be of any value to anyone, Paul? Why would that be of any value to anyone?
No, I think it's just...
No, but why? But why would someone ask him to do that? Ask yourself that question.
Exactly. But all I'm saying is that, you know, the sort of chat amongst supporters is very much a case of, you know, would he take an Alford plea? Would he not take an Alford plea or the equivalent of it? I mean, you know, look, I'm absolutely sure, you know, that if Governor Evers had any common sense whatsoever, he would have looked at this case and said, what on earth is going on here? Let's have a review of what the heck. Get Stephen Brendan out and let's find out what the F went on here. Right? If that was me.
Yeah. That's
but
what you hope somebody's going to eventually decide at some point.
I realise that there's you know, there's sort of political sides to this, and there's you know, there's votes to be won, and there's electorate out there, you know. But
I think the important thing to keep in mind is that there's a court process that deals with Brendan's appeals, right, which he has largely already exhausted with the discovery of, you know, new evidence. This is not about, you know, subjugating the court process in any way. This is about an individual man, like the president can on federal matters, simply say, I pardon you. They don't have to have a reason other than the reason that they formulate for themselves. It's not, they're not trying to say, oh, you know, federal court, trial court, appeal court, Supreme Court, you got it all wrong, I want another investigation. That's not what this is about. This is just about him exercising his authority.
Yeah. And the problem is, obviously, is that it can be very unpopular for a politician to do this. And so that's another factor that's going to be weighing on Governor Evers' mind, is the more conservative or tough on crime people there in Wisconsin will very likely be very critical of him if he chooses to pardon Brendan. And so that's another thing that's going to be weighing on his mind as he weighs the merits of Brendan's case. So that's something else to think about, because letting people out of prison is something that generally is very popular, you know, on the large scale.
Well, any politician is aware of political issues,
right?
But you'd like to think that Mr. Evers is his own man, right? And he'll judge these things on the facts and on the merits of the responsibility that comes with the ability to make that decision.
And his background is in education, so he certainly does have a care for kids. I mean, so that could be a factor as well. You know, in favor of Brendan, obviously. So. Any thoughts on that, Capaldi?
So,
well, just that, you know, he's taken quite a long time to come up with a decision, hasn't he? He's taken his time.
I don't expect that anytime soon, personally.
I mean, it's going to get to the stage where, you know, he's going to ask his advisors, you know, 6 months before the next election, do you think letting Brendan out would win me a few extra votes? Okay, let's do it then. You know what I mean? It's you know, come on, Governor Evers. You know, if you're the governor, get on and do what you're meant to do. You know, it's if you've got that power, and you know, for me, the annoying thing was always the fact that you had all these amicus briefs and scooters, because they are a joke. They just never listened to any of it.
Yeah, well,
you know, and I remember one of the discussions at the stage was, why would all of these people come on board with Brendan before Scooters had even heard it? Because it's likely to be heard. Because because what they are given is so compelling evidence, and yet the cowards wouldn't even listen to it.
Yeah, I agree.
You know, it's.
Yeah.
Sorry, Mark.
Sorry.
Mark, I was like.
Not really. The only other thing I would hope, I'd like to think, I don't know what the process is, that he'll make a decision on this sooner rather than later, and hopefully this side of Christmas. I can't think of why that he shouldn't be able to do that, but I don't know the mechanisms of what goes on here. So the matters are very well documented. They're thorough. They're in depth. Even if he says no, I'd rather him say no sooner rather than later.
Well, I suppose that one of the things that again you hear amongst the chat is the fact that maybe he's waiting to see what the state's response is to, Zellner's
right. Yeah.
Zellner's motion.
I don't think that's true.
Well,
I mean, I wouldn't.
I don't think that's true, Paul.
Seems like a possibility, but
I mean, these are, if you think that the two things are unrelated, they're related in terms of the crime connection, the alleged crime connection. But one can be dealt with without having any impact on the other in terms of the process. There's a process for governor role in pardons and clemency. There's a process for that. There's a process for dealing with Stephen's appeal. Each of those are different on different roads. Governor Evers can deal with this. I don't think he'll be at all interested in anything to do with Stephen's matter at this stage. He's just interested in what he has to deal with Brendan's application.
Right.
Well, that is the kind of, for want of a better word, neutrality you would expect. That as you say, that he can differentiate between that case and that case and realise that. But I think that there is a connection, isn't there? Because if Brendan's let out, it starts the ball rolling, doesn't it?
Well, Brendan's. I'm not saying that. I don't expect that Governor Evers will form a judgment about pardoning him of the crime. In the sense, I think that's a factual matter that may have another forum in time. But on the grounds of, for want of a better term, that's not the right term, but a humanitarian grounds based on what's transpired with him and the applications that support. They say, no, we think this young man should be released. He doesn't have to say why, by the way. It's not for him to give a reason why, other than to say, based on the application, I'm granting it. Right? It's not an exoneration. Put it that way. We're not talking about that.
No.
We would like that to occur in time, and that may well, in fact, happen on the back of things going on with Stephen. But this is just about his care and custody issue, about being in prison now for 13 years, 13 and a half years.
Yeah.
And I think, to me, the arguments are clear and they're well supported.
Oh, I believe.
And if he wants to say no, say no.
Yeah. Who knows which way he's going to go, but, hopefully he's going to see the merits in Brendan's case. So, that's going to be it for our talk here today, folks. It's lovely, always, as usual, getting to sit down with the Hodd here and the Mad Scotsman, Mad Havering Scot down there. Great guys. I'm really thankful for these guys, folks. These guys are probably the closest to me the last couple of years. I trust them really above many others. And thank you guys for being a good friend to me because it's Thanksgiving and it's a good time to let people know we care about them. So thank you for being here.
Well, I see you got Mark's name right, but the next time you put me on as the Mad Haven Scotsman, I'm going to take issue with you.
Okay, folks, I have a video that I made. It was a tutorial for Linda K. Listening. It showed me and everything that I had to do to join her StreamYard. Go look at that and figure out who it is that named him that way. And you're going to find out that it was him. So, and I got the proof. So anyways, all right. That's about it for this one, folks. Say goodbye, guys. Goodbye, everybody. It's been fun.
It's goodbye from him and it's goodbye from him.
Yeah, there you go.
Bye-bye.
Actually, you remind me of a still game joke, Paul, where they walk into the Klansmen, and Bobby says, "Oh, it's Cagney and Lacey," and they without missing a beat, Jack looks up and says, "Yeah, and it doesn't take a detective to figure. It doesn't take a detective to work out you're a bell end."
Bell end, yeah.
Yeah, right. So, anyways, hilarious stuff because Cagney and Lacey, old detective show. Anyways, hilarious stuff. I love it. Still Game's a great show. So, anyways, everybody look forward. Over on my Doctor Who channel, I'm going to have something special in terms of Brexit, Scottish independence, that whole thing going on over there that I think is interesting. Go over and check that out. If you haven't already, please hit subscribe, and we'll see ya.